the estate tax, how to avoid the estate tax and potentially save your family millions of dollars, even if you don't consider yourself to be high net worth. What are we going to cover here today? Some specific items. So we're going to go over what the death tax, the estate tax is, where we're at, and most importantly, where it's going. We're going to talk about why you might need to worry even if you don't think you need to worry. I'm going to go through who needs to really be thinking about this and why they do. I'm going to then go through 3 next level strategies to potentially save millions of dollars. I'm going to give examples. This is not the whole world of tax planning. It's just illustrative of a few examples. I'm going to talk about how you can protect your kids, your grandkids, and future generations from estate taxes and divorce and lawsuits. And then we're going to talk about how we can help and the steps that you and your family need to be aware of, to discuss, and the steps you should take. So let's go into the first subject, and that is, what do you need to know about the death tax, about the estate tax? When you pass away, if there's any estate taxes owed, the Grim Reaper's not going to pay the taxes. Your family's going to have to face those taxes, right? It's going to be a big chunk taken out. The current estate tax exemption is $12.92 million per person. That means everybody. And if it's husband, wife, you can multiply that by 2 to 25.84 million. Everybody can pass 12.92 million free of estate tax. If you're over that limit, there's a very punishing 40% tax. So it actually is about 0.1% of current families in America, about 1 in 1,000 families, maybe 2 in 1,000. But obviously in California, Silicon Valley, parts of LA, San Diego, Orange County, it's a much higher percentage. Marin County, we a much higher percentage in the Bay Area and in California on the coast. So you might think that, oh, well, 26 million if I'm married, I can pass tax-free. I don't have to worry about this. January 1st, 2026, there's a cliff coming. So we don't want you to fall off this cliff. There's a lot of ways that we can protect your assets. And here's in the exemption, it's indexed with inflation. That's why it's this weird number. It's actually $10 million indexed with inflation going back a few years, which is why it's 12.92 million this year. It's going to go up next year, almost certainly. But on January 1st, 2026, unless there are major changes in law before then, the current law sunsets and the exemption will be cut by 50%. So it'll go up a little bit before then, but then it's going to dive by 50% on January 1st, 2026. And I want to reframe how we look at these taxes, because we see these articles all the time, right? How the ultra wealthy avoid taxes and pass assets along to their heirs tax-free. And yes, ultra wealthy families do this because they have amazing advisory teams, but it shouldn't just be billionaires or multi-millionaires that are aware of these issues and who build these teams. Even if you do not consider yourself ultra high net worth, talk about the fact if you just own a house in parts of California, you could be close to what that limit will be. And keep in mind, your estate is probably larger than you think, because it includes life insurance, it includes your retirement accounts, it includes real estate. Most people, when we talk to them about their estate size, their first estimate is about 20% lower than what it actually is. We want you to be aware of these issues. And I also want to just make a key point here. I know planning with lawyers or accountants or whatever, it sounds like, oh God, I got to spend money on a lawyer. I got to do all these steps. It's so complicated. I'd actually say we need to reframe this. Estate tax planning and property tax planning, which I'll talk about a little bit later, it is one of the most extraordinary investments you can ever make. Now imagine there's some clients who we worked for where we've helped them to save millions of dollars with just a few steps. Now imagine some sort of financial product that you spend, maybe $20, $30, $40, $50,000 on, and it delivers hundreds of thousands of dollars in value to your family. It's extraordinary return on investment. And here's the other thing. So as Ben Franklin said, a penny saved is a penny earned, but I would actually go farther. A penny saved is more than a penny earned. When we're talking about saving in taxes, if you save $1 in taxes, it's actually like earning an extra $1.50 or $2. Because keep in mind, if you save $10,000 in taxes, that would have been $10,000 going out of your pocket. Well, $10,000, if you live in California, what do you have to earn to make $10,000? You might have to earn $20,000 if you're at the higher income tax rates. We get taxed at 30, 40, 50%. So if you save $1, it's actually more like earning $2, up to $2 in California. So again, I just want to reorient how we think about this. Now, so let's talk about why you probably should worry, depending on your financial situation, if you are higher net worth. And let's be clear, the Bay Area and the nicer parts of LA and Southern California, these are not normal places. We're in an area where individual houses can be worth $3, $4, $5 million. So here's kind of a rule of thumb as I think about this. If you are single, if you're unmarried, and you want to pass assets for your kids, your beneficiaries, if your net worth, and again, your net worth includes real estate, your life insurance death benefits, your retirement accounts, all your savings, all your investments, annuities, everything. If you're about $5 million today, you need to worry about this Absolutely. And if you're a couple and your net worth is approaching 10 million, you definitely need to worry about this. And maybe it's not you, maybe it's your parents, maybe it's your grandparents who are going to be leaving assets. We have many adult children who come in who drag their parents in to do this type of planning. Let's keep in mind the exemption goes up with inflation, which recently has been high. So it's going to go up 2 to 5% per year in the next few years. But assuming we enter into any kind of decent economic period, your estate's going to probably grow faster than that. Again, the last couple of years haven't been so good, but historically, estates grow 6, 7, 8, 10% a year during decent economic times. So the point is, your estate's going to grow as the exemption shrinks. And just to emphasize that point, as we think about tax planning, should I worry about this? The rule is 72. If your assets grow at 7.2% per year, they double every 10 years. So let's hope you get 7% returns, or maybe less than that. Wherever you are today is much less than where you will be in 5 years, in 10 years. So I just want to reorient. We all need to be aware of this. So the estate tax right now, not too punishing, 12.92 million per person, but it's dropping on January 1st, 2026, unless the law changes in a big way. And it could get worse or better. We don't know, but we have to plan for what we see on the horizon. Strategy number one. This is the simplest strategy to avoid unnecessary estate taxes. So this is just simply gifting. This is, let's say it's December, well, you wouldn't want to wait till December of 2025, but let's say we're getting close to that January 1st, 2026 cliff when the estate tax exemption is going to drop from where it currently is, around 12.92 million per person. It's going to go down by 50%. So what do? Well, let's say you were okay to, let's say you have a $12.92 million estate. This is Susan. Let's imagine her estate is exactly worth $12.92 million. If she gives away all $12.92 million to her kids before December 31st, 2025, zero estate taxes, right? She gave it all away. She used up her exemption, tells the IRS, I gave away 12.92 million. I used up my 12.92 million exemption. It's all protected. If she waits though, and she passes away, doesn't give anything away, and passes away on January 2nd, 2026, and the exemption drops, her estate would face a $2.37 million estate tax bill. So strategy one is you just give money away before the deadline. And it is use it or lose it, by the way. If you don't you take advantage of all of it, you get no benefit. So let's go back to that same example. Susan has an estate worth $12.92 million. Let's say she says, well, I don't want to give away everything. I want to hold on to some assets. She gives away $7 million before the exemption drops. Okay, well, let's say she gives away $7 million. She didn't use up all that $12.92 million. December 31st passes, it's 2026. She thinks, oh, I only used $7 million of the $12.92 million. I should still have some left, right? Wrong. If the exemption drops to $6 or $7 million a person, the IRS doesn't care if you didn't use any of the $12.92 million. They just look at the total you already gave and they apply it to the new limit. So if she gave $7 million or less and the exemption $7 million or less, she got zero net benefit because the rest of her estate's exposed to estate taxes. And we do have to be aware, by the way, of capital gains taxes. If you give away assets while you're alive, your kids don't benefit from a stepped up basis when you pass away. So this is a very simplistic example, but just to make the point that it's a use it or lose it type of thing. If you don't take advantage of the full exemption before it drops, it's not like you can use the leftover amount you didn't take advantage of before and apply it later. It's use it or lose it. Let's go to a more sophisticated strategy. Maybe you remember this scene where Andy Dufresne, he's doing work duty and there's this psychotic prison guard and who's always threatens the prisoners. And there's this moment where he just turns around. He hears the security guard, the prison guard, talking about a tax problem. He's like facing this big tax problem. And Andy Dufresne takes a huge risk and he turns around and he says, do you trust your wife? And the prison guard goes crazy, of course, like, what did you say? He says, do you trust your wife? And he grabs him, he holds him over the edge of the building. He's about to throw him off the top of this building until he hears that Andy Dufresne is actually talking about a tax strategy. And that brings us to the Spousal Lifetime Access Trust, the SLAT. So that's where this ties back together. Do you trust your wife or do you trust your husband? And if you do, well, I have a tool for you. The strategy number 2, a Spousal Lifetime Access Trust. One spouse, a husband or wife, sets up an irrevocable trust for the other spouse using up his or her $12.92 million exemption. It has to be their separate property assets. So if it's community property assets, you ideally want to separate them out right before you do this. Or if you have separate assets, you can already do that. So let's say a husband wants to protect assets for his kids and for his wife. Before that exemption drops, he says, hey, IRS, I'm creating this irrevocable spousal lifetime access trust. I'm using up my $12.92 million in exemption, and I'm putting in this trust for my wife. Now, there's a risk. If the wife leaves, husband can't get it back. He has made an irrevocable gift for her benefit. But here's the benefit of this for the family. it future-proofs your plan. One, you've locked in the full 12.92 million, and two, you've taken future growth out of the estate because you've used up the exemption. But let's say the husband lives another 5-10 years and the value of the assets in that trust grow from 12 million to 15 or 20 million. All of it is protected from estate taxes because he's essentially maximized the amount he's protected and frozen future growth out of the estate for future estate tax exposure. If you use a 12.92 million exemption and the estate, let's assume it's just, that's all that happens. You just use the 12.92 million, put it in the SLAT, and then God forbid someone passes away the next year, January 2nd, 2026, after the exemption drops to 7 million, you're saving a minimum of $2.4 million. And it's still in the spousal estate, right? It's not all to the kids or anything like that. So let's just give an example of how this might work. So let's compare Fred and Wilma versus Homer and Marge. So you may know Fred and Wilma from the Flintstones, and obviously Homer and Marge from the Simpsons. Let's say they both, from their royalties from their TV shows, they have large estates between the two of them. They each have $17.92 million estates in 2023. Fred and Wilma, they take steps before the exemption drops and they create a SLAT. Fred creates a spousal lifetime access trust for Wilma, uses the 12.92 million, puts it in the SLAT. Homer and Marge, obviously Homer doesn't plan, right? He just wants donuts. So they don't plan. They have the same size estate. Both couples live another 10 years and their estates grow. They invest well, they get more royalties. Their estates grow to $30 million each. What happens? What's the difference? So let's just illustrate this. Let's say you don't use strategy number 2. Homer and Marge didn't plan for estate taxes, but they invest well. Their assets grow to $30 million. The exemption drops to $7 million. When they pass away, each of them can only protect $7 million. So you add that together, $14 million protected. But hey, that leaves $16 million of their $30 million estate exposed to a 40% tax. Over $5.6 million lost to the IRS in taxes. Their children say, hey, look, Bart and Lisa and Maggie are going to be fine with that $24.4 million. That's over $5 million lost to the IRS. Fred and Wilma, on the other hand, if all they do is set up the spousal lifetime access trust, well, what happened? So they had a $17.92 million estate, $12.92 million went into the SLAT, $5 million left out of it. They didn't do any planning for that. So let's say the value of the assets in the spousal lifetime access trust grows to $20 million. Assets outside of the SLAT grow to $10 million. So that's totally unprotected. The exemption, same as what Homer and Marge faced, drops to $7 million per person. They save $4.4 million in estate taxes because they protected a full $20 million. Remember, the SLAT protects $12.92 million today, but as those assets grow in value, it's all out of your estate. It's not touched by estate taxes. So even if that grows to 20 million or 30 million, untouched by estate taxes when the parent passes away. And it goes to the children, tax-free. Now there's some of their estate is exposed to taxes because they didn't take other steps to protect that. But again, $4.4 million saved. Just want to emphasize the power of that. And keep in mind, if you're saving $4.4 million in taxes, that's like earning $6 or $7 million. So to save $4.4 million for your family is in essence earning another $6 or $7 million. So just to show the power of estate and gift tax planning. Strategy number 3, using LLCs. And I think it's really important to think about how the IRS looks at valuations of assets. And they look at control, and discounting. So there's a concept where if you give up control of assets, you can discount the value of those assets when it comes to taxes. So let's say Sally has over $15 million in assets. She could face at least $3.2 million in estate taxes if she doesn't take any steps to plan. So here, Sally, she's not married, but here she transfers her assets into an LLC. She shifts the assets to benefit her children, but she keeps some control and she gets to take some income from the LLC. We would set up, and this is where it gets next level, the LLC could be owned by trusts for her children. Sally keeps control of the LLC, but gives up ownership of the assets in it. The key thing here is if we structure this correctly, we can often get discounts. So you can often get a 20%, and don't quote me on this, it varies on the steps we take, but let's say it's 20% discounts if Sally has control of the LLC but not ownership. Because it's for the benefit of her kids, but her kids don't own it, don't manage it, Sally does. So I know esoteric, but you can get a 20% discount, meaning she can put $15 million into this LLC, and after the discount, because she controls but her kids' trusts own it, it's down to $12 million or so. So we can protect all of this, we can save $3.2 million. There's a lot of other capital gains tax issues, control issues, family dynamic issues, but this is another example of where we can basically totally legally make a big chunk of someone's estate vanish for estate tax purposes. And again, totally legally, these are accepted strategies. If you're a practitioner and expert on this, and Francis LaPole in our office is one of the world's country's best experts on this, not the world's, because I guess people outside of the United States don't care about United States estate tax laws. He's one of the best, and we all work together to help families on this. So let's talk about just some other strategies. There are irrevocable trusts where a beneficiary can disclaim a gift. There are charitable remainder trusts. We love when our clients have charitable goals and helping them to accomplish that, where you can put appreciated assets in a special trust that says, hey, when I pass away, the assets in this trust are going to go to charity, but in return, you get a tax break up front and you get lifetime income from those assets without taking a big capital gains tax hit. There are personal residence trusts where you transfer a home into a special trust. It's a way to remove future growth in the value of your home out of your estate and sometimes get other discounts. There are grantor retained annuity trusts where you can put stock. You put in these special trusts, you can get discounts. There are irrevocable life insurance trusts where you set up a special trust that actually buys a life insurance policy for you, totally out of your taxable estate. And we often will use multiple tools. Now, we're big fans of keeping things as simple as we can and as elegant as we can. We don't want to do too many tools. But I think the point here, again, there is no one size fits all approach, but there are a lot of options out there to potentially save, truly millions of dollars. And I want to spend just a minute on charitable giving because we love helping families with charitable giving. Before Gilfix and the Paul was founded, my parents, Michael Gilfix and Myra Gerson Gilfix, ran nonprofits for years. They started America's first free legal aid program for elders, SALA, Senior Adults Legal Assistance. So charitable giving is a very simple way to avoid taxes. One very simple strategy is, hey, if I'm over 12.92 million, the first 12.92 million goes to my kids, and anything over that, I'm going to leave it to charity. And anything you leave to a right kind of charity is tax exempt. Now, if you want bigger charitable goals, if you want to leave hundreds of thousands or millions of dollars to charity after you're gone, and if you want to involve your kids for charitable cause and get them involved in a win-win way to help nonprofits and to give back, you can create a family foundation. We've helped many families to set up family foundations. And this is where, if you really want your kids to be involved in an ongoing basis, you put money into the foundation. It does have annual requirements. You have to file with the IRS every year, with the state, and you have to spend a certain percentage of the funds in the family foundation every year, but it can pay a salary to people who manage it. It can be kids or grandkids managing that, and it can support charities over the long term. And you can do fundraisers. You can also do donor advised funds, or more passive, where you put money into a fund and maybe your kids can be involved in directing where the assets go down the road, but they're not that active. A family foundation is a wonderful way to have family involved, maybe for multiple generations. And again, they can raise money into it in the future, put on parties and fundraisers, and support many, many different charities. So charitable giving is another wonderful estate tax planning tool that we want you to be aware of. Let's talk now about strategies that really any family can use to avoid estate tax, or just avoid taxes in a very efficient way, to not worry about it. You might be thinking, well, I'm probably not going to get close to the limit, or maybe I'm at the limit, I have to do something, but I just want to take steps to benefit my kids and grandkids without stressing about taxes. So what are some really powerful ways to do that? Well, you may be aware of the annual exemption. So this is different from the estate tax exemption. That's how much, the estate and gift tax, that's how much you can give away during your life that is not tax exempt. You can give $12.92 million away up to that. But you may know that every year you can also give anybody you want up to $17,000, and you don't even have to report it to the IRS. So you can give, if it's your husband and wife and you want to help out your kid, you can give them, each of you can give them $17,000 in a year, and you don't even have to report it to the IRS. They don't have to report it, you don't have to report it. It's exempt. Let's say you have grandkids. One way to do it in a very tax efficient way is to use that $17,000 gift. But you probably don't want to give that to an infant, knowing that that infant, when they turn 18, is going to get full control of it. Well, there's a special trust for that. It's called a Crummey Trust. And you can give $17,000 a year. Crummey's named after a court case. I know it's a crummy name. And it's actually designed for giving to young relatives. With a Crummey Trust, you can set up ongoing trustees to oversee the money for your grandkid until they reach the age that you choose. And that if you're a grandparent, you might name the parents of your grandchild as the trustee of that. And they have wide discretion for how the money can be used. They can invest it, it can grow, and you can make sure that your grandchild doesn't get it on the day they turn 18, where it might inadvertently turn into a Lamborghini rather than a college education or a down payment for a house. So another area we want to be very careful of. But so Crummey Trusts are really powerful. Another thing, independent of that $17,000 exemption, is the fact that you can pay for medical expenses or educational expenses. And as long as you write, for the benefit of a relative, and as long as you write that check to the institution, like to the school or to the hospital or the doctor directly. You wouldn't want to give the money to your kid for them to pay the bill. But if you pay those bills directly, that can be tax exempt. Now, talk to your accountant about this. I'm not an income tax expert, but I know from an estate and gift tax standpoint, that can be a very efficient way to help out family while you're alive without involving those pesky lawyers and to save money. And it can add up over time. Imagine if mom and dad give $17,000 a year for the benefit of a kid or a grandkid. Over the years, that can be hundreds of thousands of dollars tax-free, no matter what happens to the estate tax laws in the future. Don't forget about Prop 19. But even if you don't face estate taxes, if you owned a house or rental properties in California for a long time, and if the assessed value for tax purposes are way lower than the fair market value, you need to be aware of the fact that parent-child transfers of property are no longer really protected from property tax increases. That for rental properties, when you pass away, unless we plan full reassessment of property taxes, it can be tens of thousands of dollars a year. Even your home, even if your child lives in the home after you're gone, a lot of people think it's protected. Wrong. Only $1 million in fair market value is protected from a reassessment. So if your home is worth $2.5, $3.5, $4 million, $1 million in protection from a reassessment. If your child's living there, it's nice, but they still might. I had a call with clients yesterday, or a meeting with clients yesterday, where their kids, even if they live in mom and dad's house, were facing a $36,000 per year tax increase. Property taxes can be brutal, and if you don't plan ahead, your kids may be stuck with tens of thousands of dollars a year in property tax jumps. And that can total hundreds of thousands of dollars over time, or more importantly, force people to move out. I had a meeting with a family where their daughter, she's not in tech, right? She doesn't make hundreds of thousands of dollars a year, and she wants to stay in her family's home after mom and dad are gone. If property taxes spike up, she can't stay. Bottom line is we can protect it. We've developed solutions for this to protect against property tax increases. And of course, we need to integrate that with estate tax planning and with capital gains tax planning, but the bottom line is we can help. So if you have questions about Prop 19 and what you can do to protect your home and or rental properties, talk to us. We've helped many, many families, and we can help you. And we can at least help you understand how it's going to affect you, and then you can decide, do I need to take action or not? So check out our Gilfix Law YouTube channel, lots of videos about Prop 19. Those are getting some of our highest numbers of views. Well, I want to now talk about an extraordinary trust that provides future estate tax protection for your kids, well, really for your grandkids, for your great-grandkids, and for future generations. Now, how do you do this? How do you protect future generations? Well, it's actually pretty simple. Don't leave them anything. Don't even leave them a penny. Not 1 cent. And you're like, okay, Mark, obviously if I don't leave my kids any money, they're protected because they have no money from lawsuits or whatever. If they get divorced, yeah, there's nothing to be lost. Wrong. I'm not saying that. I mean, you don't have to leave money to your kids. But if you do want to leave assets for your kids, but you want it to be protected for future generations, there are much more powerful tools. They're called, our version is family protection trusts. They're generically known as dynasty trusts. We talk about these a lot, but I hammer this. When you hear the term dynasty trust, what image do you have in your mind? Just take a moment. Dynasty trust. What are you picturing in your mind's eye? It might be something like this, right? A mansion, countryside, rolling gardens, butlers, but it's not just for billionaires. And it's not even just for multimillionaires. I think any family, if you own a house in California, I think you should create a dynasty trust for each of your kids. Family protection trust is our version. Now, by leaving assets, let's say you have 2 kids, you would set up a family, like a son and daughter, you would set up a family protection trust for your son and a family protection trust for your daughter. Your living trust that you have wouldn't leave money to them, it would leave money to the trusts. Why would you do that? 3 big reasons. 1, if your child endures a divorce, well, if they inherit money and they commingle it, it could largely be lost in a divorce settlement, or at least 50% of it. If it's in one of these trusts, it's not commingled, it stays separate, and it should be protected in case your child endures a divorce, not lost to that significant other that maybe you didn't like from the beginning. If your child is sued, if they inherit money directly, that's fair game. If it's in a family protection trust, there's a barrier. You're creating a very big obstacle, making it a lot harder for someone to go after that money. So people generally then settle for pennies on the dollar. And here's when the subject of this talk is really on estate taxes. And here's something really, really powerful. So we talked about how family protection trust can be layered in with other estate and gift tax planning tools. But once money is in a family protection trust, most of it is protected from future estate taxes. There are some limits here, but let's just give a broad example. Let's say you leave $5 million for the benefit of your son in a family protection trust. He uses that trust. He can be in charge of it, by the way. He can be his own trustee. You don't have to have a third-party trustee. He uses that to support himself, but he invests it really well. And that grows to 10 million or even 15 million during his life. When he passes away, it should not be touched by estate taxes because the trust just continues for his kids, your grandkids. So it doesn't protect when it goes from mom and dad into these trusts. We have to use other tools to protect. We could use the Spousal Lifetime Access Trust or LLCs. But once it's in a family protection trust, all or most of the money in that trust is protected for about 100 years from future estate taxes. It's extraordinary multi-generational protection, and they last for about 100 years in California. And even if you're just starting out with what you consider to be a smaller amount, like 50% of a home is going to go to each of your kids, $1 million each, which I know crazy that $1 million each is not that much in the Bay Area or in LA or whatever. If that just doubles or triples during your children's lives, it's protected for one generation, it's protected for another generation. It can grow, it can get that compound growth and double or triple over time. And we have no idea what estate taxes will be like in 20, 30, 40 years. But I think there's a very good argument that they could be much more strict as we go into the future. As the gap between the haves and the have-nots gets wider, I think it's very logical taxes get more punishing. Family protection trusts, or a version of dynasty trusts, can be layered in with other estate and gift tax planning. We think they are almost no-brainers for the vast majority of our clients, and the majority of our clients end up setting these up, one for each child. And if you have a child with special needs, it's a different type of trust. But they are so powerful, they should not just be for the ultra wealthy. So if you're thinking about estate and gift tax issues, what are some action items and are some questions? Should you meet with us? Could be another advisor, but should you meet with us or an expert on this? Well, I think some questions asked. Do you have an up-to-date estate plan? Has it been more than 3 or 4 years since you last reviewed it? Do you even know what type of trust structure you have? Do you own a home or rental property in California? Do you want to leave it for future generations? We have to then think about Prop 19 planning. You at least should understand what the numbers will be. And is your estate approaching 5 million if you're single, or 10 million as a couple? I know these are big numbers, but your estate's almost certainly bigger than you think, because then you need to be worried about estate taxes and we should get planning started. And do you want to protect assets for future generations or for a special needs child? Or child with special needs, we can help with that as well. And it all needs to be integrated. And just some action items for you. How important is it to you to preserve your assets and your legacy? Are there charitable goals that you have? Review your assets, and I encourage you to talk to your kids and even your grandkids about this. You don't have to reveal specific numbers. There's so much we can accomplish when we all work together across generations. I know it's not possible for every family, and there's sensitivities in different families, but I encourage you to speak with your kids, with your grandkids about these issues, about your hopes, your dreams, your goals, and you want to build that legal and financial team. There's no one-size-fits-all solution because we have to weigh capital gains taxes with property taxes, with estate taxes, and all those issues around it. We want to be thoughtful about protecting assets for future generations, and there's sometimes it is too much. Maybe you don't want to protect it all for your kids, but then maybe there's charitable goals, and how can we be creative about that? And of course, the Gilfix and the Bull team can bring it all together for you. We love to do that for families, and I'm a big believer increasingly that there should be communication between your legal and financial team, like your financial advisor, your legal advisor. You should have those advisors. And we are building some great partnerships with some select financial advisors. So if you're looking at building that team for yourself and you don't have an advisor, let us know. Or if you're looking for a new advisor, talk to us. We're building some really win-win structures for integrated legal and financial planning, sort of a family office approach. And if you love your financial advisor, we can work with them too. We love working with financial advisors and bringing them into the conversation so we can all be on the same page. Meet with us, we can take steps, and we should start planning right now. It's not just me, and it's not just Mike. We have Nick Klingenberg, Renee Conrad, Francis LaPaul, our tax guru. So we are an integrated team. We have litigators as well. We have a wonderful team, and we're actually looking to grow that team in the near future. Spread the word, subscribe to our Gilfix Law YouTube channel. We're over 60,000 views in just a few months. Not bad for a little law firm that does estate planning, not the most exciting subject for most families. And I think most importantly, if you do want to work with us, if you're an existing client, you want to come back and take a look, or if you haven't met with us, we do have limited availability. My calendar now gets booked out a couple weeks in advance, and Francis LaPole's does get booked up pretty far in advance. But we absolutely welcome the chance to work with you. We just need a little bit of advance warning, and we can set that meeting with you and explore these issues with us, with you, to make sure. So you can contact us at gilfix.com, 650-493-8070. I hope everybody's staying safe, sane, and healthy, and we'll see you again very soon.